a suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is back with you to help you out with any legal problems you might have. 1300 222 774 is the number. And I've got a few lines free. In fact, an unusual number of lines free. So you must all be fair and square and sorted with all the legal problems. That's great to hear, although I somehow don't think that's the case. So if you'd like to take advantage of the rare opportunity of there being a couple of lines free, grab them. 1300 222 774 because David Whiting can help you. Morning, David.
Good morning, Virginia.
Did you have homework from last time round?
I did. I had one from Neil of Bentley, and he was talking about changes in owners' corporation rules. Now, for owners' corporations, there's a set of model rules, and the model rules apply from the time of registration of the plan. So Neil's question was, if the owners' corporation rules contained in legislation change, do the model rules that apply to an owners' corporation change at the same time? And I think logically the answer is yes, they do. Section 32 of the Interpretation of Legislation Act is the guide. And so every time they change by legislation, and there were a few changes last year, they apply automatically to all existing owners' corporations. If they fill a gap in some additional rules that and if there is a gap in rules that the owners' corporation adopted for themselves that are covered by the model rules, then the model rules apply to the extent of any inconsistency. But the interesting one was a lot owner or occupier in a multi-level development must ensure that smoke caused by the smoking of tobacco or other substances by the owner or occupier or any invitee does not penetrate to the common property or any other lot.
I'm sure that's the requirement, but we just you and I alone, have had call after call of people saying that that's going on in their apartment.
Oh, this came in the middle of last year. So now it's a breach of the model rules.
Okay.
And then you follow the dispute processes, but at least you've got something to do with it.
You got something to stand on now, because you actually point to that and say, you can't have that. I can smell it. It's interfering with my, happy enjoyment of...
Well, no, just the mere fact that I can smell it is the problem, which means that the smoke is penetrating.
Yeah. Okay.
Well, I remember one a couple of years ago where it was a North Melbourne and a log fire, where that wouldn't cover that one, but it certainly covers smoke and other substances. We've come a long way. There was a time we would have never added or other substances.
That's right. And I don't know what you're talking about.
Yep.
7 minutes past 10, the number's 1300 222 774 if you'd like some help from David Whiting. Julie in Ascot Vale, go ahead. Good morning.
Oh, good morning. How are you?
Well.
David.
Fire away, Julie.
Thank you. David, my partner died about 8 months ago, and he was 56 years old, and we had been together 15 years in a de facto relationship, and he had not left a will, or so we thought.
Yes.
And we were in the process of actually, he was kept telling me that we should write one up, but I resisted it, given my own issues around death. He died suddenly of a heart attack at work. I was granted letters of administration.
Yes.
And 2 days later, his parents found
a will. Okay.
Yes. An old will dated 1997.
Yes.
And they have produced it, obviously.
Where are you want to get to, Julie? So technically what happens now is that you tell the registrar of probates that there has been an earlier will found. That will result in your grant of letters of administration being revoked. And what then happens is someone needs to make an application for either a grant of probate or letters of administration with a will annexed for that document, and you then challenge it. Right.
And then I challenge it.
Yes, you
now,
do.
in the meantime, my main concern in the meantime is that the property that I'm living in is in my partner's name.
Yes.
I have lived here for 15 years and I don't have anywhere else to go. How easy is it for them to ask me to vacate the property?
Well, asking and going are not the same, Julie. Let them ask and then have the argument. Under the Administration and Probate Act, you've got the ability to challenge the will. You also have the right to acquire the property. So there's a provision there that allows you to acquire it using your part of the estate to pay for it.
Is there any recognition of Julie as a de facto here, though, in this property?
The answer is there will be, but as part of the challenge process.
Right.
Now, if you make a will, then the situation's clear. Julie's partner didn't have a will, so there needs to be an argument as to priorities and moral obligations.
Mm-hmm.
You would think with a 15-year de facto relationship she'd get certainly most of it, if not all of it. But we don't know what other claimants there might be on the estate. So, Julie, I don't see you being moved in a hurry. And what you would, if you really needed to, you'd go to court to get a stay until such time as your claim's resolved.
Julie, do you have a working relationship with his parents?
No, I do not.
Mm-hmm.
Then hang in there, Julie. Don't move. They have no more stand. They have no standing until they get their application up. But you should consider notifying the registrar of probates that a will's now been found. There'll be a process for the revocation. But just stay where you are.
Okay.
All right.
Great.
Good luck,
Thank
Julie,
you.
and I'm sorry to hear about your sad news, and good luck with that. Gabriel in Brunswick, go ahead.
Thanks, David and Regine. I got a question to clarify. My wife and I are born 3 days apart. So my wife is older.
So did you marry a younger woman or an older woman, Gabriel?
An older woman.
Okay. Yep.
So I got a question. So how does our will work? So let's say we go on holiday and then we kick the bucket.
Okay, well, let's assume the plane goes down. Let's be really bleak. You will be deemed to, absent evidence to the contrary, you will be deemed to have died in order of age.
Right.
Now, there are two other things that you need to think through. So let's say you own your house jointly. Then upon your wife's death, you become the sole owner of the property, even though simply because you've been deemed to die in that order. And in terms of dealing with the house, it will be dealt with under your will. If we're talking about something else that your wife might leave you, say money in a bank account in her name, the Administration and Probate Act says that there is a presumption that if I'm leaving you something in my will, then you need to survive for 30 days in order to get it.
That's right, yeah.
So if that was the case and it had applied to you, then you would get the house on the instant of your wife's death, and then your wife's bank account would be dealt with under her will.
All right. Okay.
So which is why when you give instructions for a will, you normally turn around and say, if I'm survived by my partner, then I want this to happen, and if I'm not survived by my partner, then I want this to happen.
Good luck, Gabrielle, and you can usually make that quite clear. Susan in Blackburn, hello.
Yes, good morning. I'm ringing about a property I have. I've been in my house for about 26 years. I got new neighbours about 4 years ago, and they've a bit of a nightmare, long story. But the fence line has been in the wrong place, and they have a good section of my land. I'm wondering how long they have to have it fenced and whatnot, or have to have owned the block before
Susan,
they can claim
has the fence been in the wrong place for the 26 years you've been there?
Roughly, yes.
Okay. Then it starts to get a bit messy because your neighbour's only been there for 4 years. Now, but it is possible to acquire someone's rights by adverse possession. So if your neighbours, your new neighbours, went to your old neighbours, who I assume were there for 10 years or more, and they bought the adverse possession rights that your previous neighbours have, then it could be argued that you've lost your right to the land and you've got nowhere to go. But if you know where your former neighbours have gone to, you might buy back the adverse possession rights that they had in respect of your property, and then your 4-year neighbour has nowhere to go.
So when you say buy back, because I'm still friends with my old neighbour, there's actually 2 neighbours in that time, one for about 3 years and one for 20-odd years before that, who's still a really good friend.
Well, why would you just not go back and buy the 20-year one, because then your neighbours only have 7 years?
So when you say I buy, how do I buy?
You need a document that constitutes an assignment of possessory rights. So insofar as I ever had any possessory rights to Susan's property in Blackburn, I now transfer those as possessory rights to her. And then you're in a position to say to your neighbour, I need the fence put back in the right place.
Oh, David Whiting, I think I'd love for you.
Well, okay, right, it's a long list, Susan, I should tell you. But can I say, it's a really interesting question that you put me, position that you put me in, because my first question is always, who's my client? Now, the advice that I've given Susan is how to defeat the neighbour's claim.
Right.
The advice I would give the neighbour, if it was the neighbour was calling,
Well, the neighbour's next on the line. I'm just about to go to them now.
Thank you for that.
Yes.
Would be to go and buy the possessory rights from earlier on.
Oh, I'm sure they heard that.
Yes. Okay.
What a terrible fight to have. Oh. Before I let you go, Susan, how much land is involved here?
Not a lot. Probably, look, I don't know, maybe 100 square metres.
What is it, metre wide or what, 2 metres? So you're almost taking their driveway.
It's like a no, they're on about half an acre and I'm on about a third of an acre.
Okay, it's not quite as bad as I thought.
Okay,
right?
but still,
Absolutely.
land is land is land.
Yes.
And if it's supposed to be yours, then I guess you need to somehow secure it. Good luck, Susan. Let us know how it goes. And if the other neighbour is listening, well, no, I won't. I won't stir that pot. Jennifer in Geelong, go ahead.
Hi, David. Just inquiring about using stacking boxes in cars when you're travelling. People have just returned from holidays. Their cars might be stacked up to the top. And I'm out now actually just collecting things from a volunteer perspective, and my car is chock-a-block. Do I have to be able to see through the rear vision mirror?
No.
Or can the side mirrors be enough?
Side mirrors can be enough. You need to think logically, Jennifer. There are lots of trucks out there that don't have a rear vision mirror because there's a very large trailer behind them, but they have side mirrors.
Well, that's what I thought, but I was told that cars are different. And I looked up the relevant act, and it just sort of said it wasn't really clear for a car. So that was my argument. A truck has a rear vision mirror, but you can't see out the back. But so my side mirrors are enough?
Your side mirrors are enough.
Awesome.
All right, but Jennifer, make sure that your load doesn't move around. There are lots of rules about loads that are not properly secured.
Inside the car?
Oh, I'm just thinking from a safety perspective rather than a legal perspective.
Sure.
You don't want the box to move.
Well, no, of course. That's the worst thing when it comes flying at the back of your head when you hit the brakes.
Yeah,
yes.
The only thing you're required to secure inside a car is passengers and pets.
I was going to say the dog. Don't want the dog to come flying and hit you in the back of the head either. Gone close there a few times. Good luck with the move. Surinder, let me see if I can grab that line again, just being a bit tricky. There we go. Surinder in Terralgan, you're on the air. Go ahead.
Good morning, David and Virginia. My question to David is 2 years ago, I got a seatbelt fine. As a courier driver, I thought I'm exemption for not wearing seatbelt if I'm going under certain speed limit or less, just the next door. And the police gave me a fine. And
Surinder, no exemption for delivery drivers.
Actually, I just check on the Vic Road website, and it's clearly said that. I don't know which one is right.
All right, then I'll take that as homework then, Surinder, but I will come back and tell you I do know that the legislation used to say that in order to not wear a seatbelt you needed an exemption. So just, because I thought I could, I applied for an exemption. I should tell you I got rejected. I had no valid reasons for applying for one. But,
what are the valid reasons?
No, there aren't any.
Oh.
You can apply for an exemption. They just don't tell you what the valid reasons are.
Vic Road only said if you're driving less than 25 kilometers and under certain, the delivery driver is exemption for that.
Okay, but you just so is your view that you met the requirements or not?
Yes.
If you met the requirements and you got rejected by Vic Roads, you can take the matter to the Magistrates Court.
Actually, I tried to call them and they said once you pay the fine, you can't go to court.
That's exactly right. It's called, the answer would be once you've paid the fine, there's nothing to argue about.
Yeah, you've admitted to it. Surinder, why don't you want to wear a seatbelt?
Actually, just I was doing delivery across the road, and then next driveway I was driving in, and the way the police park in the same driveway, that's just like 5 meters on the side of the road.
You mean
They saw me exactly physically. I'm just
It was just 5 metres you weren't wearing. You ordinarily wear the belt, do you?
Just a 5 metre.
Right. David, where does this
Surinder,
go?
I shall have a look next week, but if you've already paid the fine, you haven't admitted the offence, but there's nowhere to appeal. There's no outstanding charge that can be dealt with in a magistrate's court.
This is according to the Vic Roads website, with thanks to Katrina and Kelsey for putting this together for me. There are a number of other exemptions, non-medical, from wearing a seatbelt provided by the Victorian Road Safety Rules 2017, including when a person is engaged in door-to-door delivery, collection of goods or collection of waste or garbage, providing the vehicle speed does not exceed 25 kilometres an hour.
Okay.
Or kilometres, I should say.
I'll take either.
So I guess, the garbage truck driver who's kind of, just ambling slowly along the side of the curb while someone's helping with the rubbish, they don't have to.
Yeah, and sometimes there's it
would be still
the
wise
garbage
to.
truck will have a jockey that sits in a little box on the side.
That's right.
Yep.
And you don't want to be clicking in and out, I suppose. Surinder, have a listen, because David will have some more information for you next week. Andy is calling from Tassie. Go ahead.
Good morning, Virginia and David. I have a question about a de facto partner's ability or right to claim part of my assets if and when the relationship ends, because, my relationship is progressing to the stage where we're considering living together and becoming sort of...
Well, sorry, stop there, Andy. Do you yet have a de facto relationship? Because it may well be that if you're not living together, you may not yet be at that point. So you're saying your de facto relationship is moving to the point where you might live together?
Yes, that's right.
The living together, even if you live in two houses together, is when, under Victorian law, one of the best indicators of the existence of a de facto relationship. Weekends don't count, as it were.
Right.
So why would you not, if that's a concern for you, why would you not do an agreement that covers the situation and get advice in relation to it for you and your partner? So effectively, you're doing a property settlement before you move in.
Right. Yeah. Sure. Look, that's an answer that that maybe I was looking for. And who would I speak to about sort of making this kind of agreement?
You would go and see a family lawyer, and and really it's a question of whatever deal you strike with your future partner.
Yeah. Yeah.
What you need to do, though, Andy, is make sure that you've covered the situation. So if your agreement doesn't cover the possibility of children, you need to make sure that it does. You might also consider making changes as to what benefits you confer depending on how long the relationship lasts.
Yeah.
Yep.
Yeah. Sure.
Good luck.
Thank you very much.
And most importantly, I hope it turns out to be a terrific, lasting and loving relationship, which is the thing that has to matter most, right?
So you never read the agreement. That's where you want to get to.
Yeah, exactly. So, yes, it's never, ever pulled out of the bottom drawer ever again. That's our wish for you. Les in Maribyrnong, go ahead.
Hi, David. Just a query. Had a verbal agreement with an individual to rent a residential property. Now, what I understand is the person's part of a collective which try to assist marginalised people. Now, they put a young lady in for a short period of time. But,
sorry, you've stuck me for a moment. Have you reached an agreement with the renter, or have you reached an agreement with an organisation who then puts their own people in?
With the renter.
So there was an introducer, if you like. So you've been introduced to the person renting your property by someone else. Great. Okay.
Yes. Okay. So they was introduced to that individual. They said they'd continue the arrangement. Said, great, that's fantastic. Then I find out that they've actually placed someone in there just to assist them for a short period of time. They tried to move them on. When I say move them on, to help them out, but they obviously didn't want to leave. Then the girl's partners moved in as well, and they've been there for some time. Now,
how long is some time, Les?
Probably 12 months.
Oh, well, then what you've got is you've got an agreement between you and the tenant that gives them effectively the same rights as a residential tenancy because of the time they've been there.
Okay, now they haven't paid that other individual any rent whatsoever.
Are they paying you any rent?
No.
So the number, the problem here is that you're not being paid rent. Is that the issue you're asking about?
No, we actually want them to move on because we want to...
You want them out?
Yeah.
Okay.
Are you going to sell the property or demolish the property?
Well, we're going to renovate the property.
All right. Then there are, about Section 91 of the Residential Tenancies Act, are a whole series of provisions about terminating tenancies and the amount of notice that you need to give. Now, one of them allows you to give very short notice, I think about 14 days, in circumstances where the rent's not paid.
Yep.
All right? So do you have a managing agent? Do you have someone looking at it for you?
No.
Then you're going to need to get some advice to make sure you give them the right notice to terminate the tenancy.
Now, I don't have an agreement with the people that are living there.
Well, as we went through that, you told me they were your tenants.
No. The girl the person A, who has never lived there, was the person I had the agreement with.
Well, then the answer would be you have squatters in the property and you can issue proceedings for possession.
Okay.
But their argument will be they have a residential tenancy agreement with someone. Les, for the cost of a house, and is going to be $750,000 or whatever it is, go off and get some proper advice and sit down and say, here are my issues, here are my facts, where do I go from here?
Good luck with doing that. We're going to finish this morning with Andy in Ivanhoe. Go ahead, Andy.
Oh, hi, David and Virginia. I'm just ringing. We had it's with my husband and his siblings. I believe it could be a misrepresentation of legal advice or absolutely no legal advice whatsoever. My husband's father died in 2005. And the will stated that everything had to be sold, all assets other than monetary were to be gathered.
Yep, turn into cash and distribute the proceeds, yes.
And distribute it, yes. But what happened was that the house was not done. It was not done by that. My husband had been caring for his father from 2002. And he continued living in the house because the other siblings had properties of their own. He didn't. So they said, look, you just stay here. And that's what they did. And he's never paid rent or anything like that. And this property was sold in November last year. And as it turned out, the property was sold in the estate. It wasn't sold in their personal names.
Yes.
And the CGT on that and land tax as well was exorbitant. It was
extended. It was significant, yes. Yep.
Oh, very significant.
I might have to get you to the point.
So what's
here,
the question, Andy?
Yeah.
Yes.
What's your question?
My question is, if the lawyer that was employed by the executors hasn't done his due diligence, as in
hasn't done what he was instructed to do
by the will, yes.
No. It's instructed to do by the executors, because they're the people who are ultimately responsible for the administration of the estate. If you don't think the lawyer's done his job properly, or his or her job properly, then you can take the matter up with the Legal Services Board or the Legal Services Commissioner, or go to the lawyer and ask for an explanation as to why.
Well, we did ask at one stage why only one executor was ever contacted, and his comment was that my husband was too hard to get in contact with over 17 years, even though this
Andy,
lawyer,
it's exactly the same. I mean, I can't give you advice in a minute that would match what you'll get from the Legal Services Board, and if you've got a complaint, take it there.
Andy, we'll have to leave you there with that. David, thanks so much. See you next week. David Whiting there, who's always so helpful with legal advice.